Hi, everyone, and welcome. Thank you for joining the USPTO Trademark webinar series on the Madrid Protocol. Today's topic is international trademark applications originating from the United States. Our speakers today are Kelly Cho and Debbie Lee. Kelly Cho is an attorney advisor in the Office of the Deputy Commissioner of Trademark Examination Policy, where she serves as one of the Madrid Protocol liaison attorneys on the petition side. Prior to joining the Petitions Office, she worked in the Office of Trademark Classification Policy and Practice as a senior attorney in Law Office 109, and prior to that as a trademark examining attorney. Debbie Lee has been an attorney advisor with the USPTO for over 15 years. She currently works in the Office of the Deputy Commissioner for Trademark Examination Policy, where she serves as one of the Madrid Protocol liaison attorneys on the policy side. Prior to joining the Trademark Legal Policy Office, she was an attorney advisor in the Office of Policy and International Affairs, where she provided advice regarding trademarks and geographical indications across a variety of regions. Prior to that, she was a trademark examining attorney for 7 years. If you have questions during the webinar, please post them in the chat window of this presentation, and time permitting, we will respond at the end of the presentation. Without further delay, I will turn this over to Kelly.
Thanks, Katie, and good afternoon, everyone, and thank you for registering and attending today's webinar. I am Kelly Cho, and I will start off today's presentation, then pass off the more complicated aspects to my colleague, Debbie Lee. Before we begin, just want to let you know that we will be covering a lot of information in 1.5 hours using Madrid Protocol specific terms and moving relatively quickly through the topics. So if you find that you would like to learn more, you can find additional information and resources about the Madrid Protocol on the USPTO website, and this presentation will also be made available on the website. So let's begin. Next slide, please. So this is our roadmap for today's presentation. We will start with a general overview of the Madrid system, then focus on the USPTO as the Office of Origin for filing and certifying an international application, and if the international application is denied certification by the USPTO, what your options are, including filing a petition. Later, we'll cover the notice of irregularity and also touch on post-international registration issues. Next slide. The Madrid system, what is it? An international trademark filing system for registering and maintaining trademarks worldwide through a centralized mechanism. Underpinning the Madrid system are 2 treaties, the Madrid Agreement concerning the international registration of marks and the protocol relating to the Madrid Agreement concerning the international registration of marks. The 2 treaties are referred to jointly as the Madrid system. And so you may hear these terms Madrid Protocol, Madrid system used interchangeably, but note that the Madrid Protocol does refer to the treaty. The Madrid system is administered by the International Bureau of the World Intellectual Property Organization located in Switzerland. And in the interest of brevity, I will probably just refer to the International Bureau as the IB and the World Intellectual Property Organization as WIPO. So why use it? It is cost-effective and efficient. You file one application through one office using one language and pay one set of fees. And with 106 current members, you can seek protection in 122 countries. And once your international registration issues, management of your international registration portfolio is centralized through the International Bureau. Next slide. So this chart shows the filing process using the Madrid system. You would start with a national or regional trademark application or registration. This is your basic application or basic registration and forms the basis of your international application. In your international application, you select or designate the countries you are seeking protection in. And you have 122 countries to choose from. And these designated countries are the contracting parties. The international application is filed with your national or regional trademark office, which is the Office of Origin. So your Office of Origin will then review the international application and certify if all filing requirements are met. Then submit that international application to the International Bureau. Upon receipt, the International Bureau will review the application for formalities only. This is not a substantive examination. Once that review process is complete, the IB will issue a registration certificate, and this is your international registration. Then the International Bureau will notify each of the contracting parties that you designated in your international application with a request for extension of protection. This request for extension of protection has the effect of a national or regional application filing in that designated country. It is then up to each designated contracting party to review that request for extension of protection to determine scope and registrability under its own national laws. So this means a refusal may issue, but if no refusal is made, generally a 12 or 18-month deadline, the effect is a national or regional registration in that designated country. Next slide. So this chart shows the filing process from a slightly different perspective. The main point I want to make is that the Madrid system is a filing mechanism only, that the International Bureau issues an international registration, then notifies the designated contracting parties with a request for extension of protection. This does not automatically grant protection in those countries designated. Effectively, you now have or depending on how many countries you designated, multiple pending national applications that you must then prosecute. So the scope and for that matter, the registrability of your request for extension of protection will be determined under the relevant national laws of the designated contracting party. And if you are successful in registering your mark in that country, be aware that separate maintenance filings may be required to maintain your registered extension of protection. So while the benefit of the Madrid system enables you to centrally manage your international registrations through the International Bureau, including renewal, just be aware that a single renewal filing at the IB may not be sufficient to maintain protection in the designated contracting party. Next slide. Sorry about that. The next two slides cover noteworthy aspects of the Madrid system. An international application can be based on one or more applications and/or registrations for the same mark. When filing through the USPTO, all fees are payable in US dollar, and the relevant fees include the basic fee, which is payable to WIPO, and currently that's 653 Swiss francs and 903 Swiss francs for color marks. There's also fees payable to the designated contracting parties, which is generally per class of goods and services. And also not listed on this slide are the USPTO certification fees. And as previously mentioned, the relevant national laws of the designated contracting party will determine the scope of protection. Additionally, the international registration is dependent on the scope of the basic application of registration for 5 years. If the basic application of registration is canceled or limited, so is the international registration, and by extension, the designations. Also, once the international registration issues, you can subsequently designate additional countries. The dependency and subsequent designations will be covered again later in the presentation, so I will move on to the next slide. Another noteworthy item that we'll go into more detail later is that the scope of rights in the international registration may not exceed those in the basic application or registration to include the type, representation, and description of the mark, identification of goods and services, and color claims. Next slide. And for these next slides, Debbie will be taking over.
Thanks, Kelly. Following up on what Kelly was talking about, one of the advantages of the system is that it is centrally administered at WIPO. And the main point on this slide is to explain how the operations business units of the IB are organized. So they have 4 teams, and there is one team that is assigned to handle the United States. And what that means is that one team is processing our applications, processing our correspondence, also processing any maintenance filings that pertain to us. And then they're also the team that will be handling the customer service calls and requests that come in from their online form. So when you do reach out to the IB for help, the people that will be working with you will be people that are familiar with the common issues that come up relevant to our jurisdiction. They can't answer legal questions, but they are they're familiar with the more common questions. And they also have points of contact at the USPTO in case they need to coordinate with us in order to resolve an issue. This slide just provides an overview of some of the legal background for the U.S. implementation. We joined the Madrid Protocol, and it was made effective in November of 2003. And we have up here references to the amendments of the Trademark Act that were enacted in order to have us join, as well as changes to the USPTO trademark rules of practice. You can find the current version of both of these on the USPTO website. If you click on the trademark link and you go to the trademark homepage, there's a section in the right-hand side that is called Laws and Rules. And under that section, you'll have access. There's actually links to the most current version of the Trademark Act, as well as the most current version of the Rules of Practice. This slide, I'm just going to skim over. It's a little bit more information about our implementation it pertains to the inbound process, and we're focusing in this presentation on the outbound, but we have it here for your information. As I sort of hinted in the last slide, Madrid is a two-way process. So the subject matter of this presentation is the outgoing process. That's the process of U.S. applicants seeking protection in other countries for their trademarks using the Madrid system. And we have here references to the Trademark Manual of Examining Procedure, that's the TMEP, that provide our policies and procedures as to that outgoing process. But there is also an incoming process for requests for extension of protection, which is just a fancy way of saying incoming applications through the Madrid system into the United States. So these are foreign applicants seeking protection via Madrid in the United States, where the USPTO is a designated country. And the treaty term is we are a designated contracting party. Beneath that, we've got references to the relevant TMEP sections that cover our policies and procedures for this half of our implementation. We wanted to make you aware that we have a specialized business unit for handling Madrid issues, and it's called the Madrid Processing Unit. It's a small team relative to the amount of work that they do. We have 9 people, 1 supervisor, 1 administrative assistant, 1 lead specialist, and 6 specialists. On the outbound side, which is what we're talking about today, the people in the MPU are responsible for review and certification of your international applications, reviewing and forwarding to the IB your responses to notices of irregularity that you might receive, as well as processing and sending to the IB ceasing of effect notices. The MPU also does a tremendous amount of work on processing transactions that come in as part of the maintenance filings that happen. So renewals and any changes to the identification of goods and services, corrections, those types of things as well. But these are just the things that they do on the outbound side. And the next couple of slides are just some information resources that we think might be helpful for you. This is the USPTO webpage for the Madrid Protocol. The link is over there on the right-hand side. It has a little bit of background information, and mostly what we focused on in the content on this page is giving you information that will help you with the inbound and outbound process as to the United States. So this is specialized information for us. One item of note that is very popular on this page is we have a document entitled Tips for Avoiding Denial of Certification. Kelly is going to discuss that topic with you in a few minutes. But I wanted to let you know that it's available. We have a document available online that covers that material as well. And then I really wanted to show you this WIPO website. This is the Madrid system homepage for WIPO. And if you can bear with me, I'm going to take you on a little brief adventure. I'm going to show you just a little bit of the content here because the WIPO website has a lot of really good user focused information about how the system is put together as a whole. And I think this is a good resource for you. At the top, you can see everybody's preoccupation right now is with COVID-19. They have information about filing flexibilities that are available during this time. I'm going to skip past news and events, although you'll see that they have video tutorials that they're advertising here. They have reference to their e-services, including a search database that you can use to do a preliminary search of your mark. So that's very helpful, but also information pertaining to the entire process. And then what I really want you to see, if you scroll all the way down this page, is information on how to contact customer service. So they have a link to an electronic contact form. They do respond. You will be providing an email address for them to follow up. They do actually follow up. You can get help this way. And then there's also the direct telephone number for Madrid customer service, and we have their operating hours here for you as well. And I'm going to switch back here. Okay. And now we're back to USPTO land. I'm going to just talk briefly about the filing options for your international application. We do have electronic filing available. You can only file in English. And the certification fees, this is the fee that we collect for reviewing your international application and then certifying it and sending it on to the International Bureau. It's a non-refundable fee. It's $100 per class if you're filing based on one basic application or registration, or $150 per class if your international application is based on more than one basic application or registration. You can pay what we call the international fees, which is the official WIPO and country fees, through us, through the form. When you file the form, we will collect the fees in US dollars. Or you can tell the form that you're going to pay the fees directly to WIPO via a WIPO deposit account if you have one. So you have those two options to pay. Also, just so you're aware, we send transactions, and when I say transaction, I mean any correspondence. So international applications, subsequent designations, any other back and forth maintenance filings that we do with the International Bureau, those are sent every day in one single batch file, so we don't send things individually. We send the fees to the IB in one lump sum once a week. And then also it's important to know that the IB sends money to us once a month. So if you're in a situation where you have sent fees that have already gone to the International Bureau and you are waiting for a refund, there is a bit of back and forth, so it takes a little bit of time to work that out. Just be aware. And continuing on to filing, we accept two types of filings. We will accept electronic filings, and in limited circumstances, we will accept paper filings. For electronic filings, we have two types of forms. If you have only one basic application or registration that you're using for your international application, you can use the pre-populated form. The advantage of this form is that it will automatically pull the relevant information from your basic application or registration for you so you don't have to type it in. If you don't make any changes to the information that was automatically populated into the form, it will be automatically certified and sent to the International Bureau. If you make any tweaks to that information, that will trigger a manual review, a manual certification review process, and that will just take a little bit longer. If you have more than one basic application or registration that you're using for your international application, you have to use the free text form. And as the name suggests, you're going to have to type in all the information into the form. So that's the option. That's the only option you have available if you have more than one basic application or registration. And as I said before, in limited circumstances, we will accept paper filings. As most of you are probably aware, the USPTO recently implemented mandatory electronic filing. So in the context of an international application, we will accept paper if the applicant is claiming a treaty right to file on paper, or if the electronic systems are not available when you need to file. So in those circumstances, we would accept a paper filing, but be aware that the International Bureau will only accept the paper filing on its official MM2 form. So that form is available from the WIPO website. You can link to it from the website I showed you earlier, and then I also have the direct link on a slide later on. And now I'm going to switch back. Kelly's going to talk to you a little bit more about electronic filing.
Thanks, Debbie. Okay, so you're now ready to file an international application through the USPTO website. There are probably slightly different ways to get there, but ultimately you want to find the Madrid Protocol forms link. Click on the application for international registration, and this page will display showing both the pre-populated form and the free text form. As Debbie indicated earlier, you will not be able to use the pre-populated form if you have multiple U.S. applications or registrations. You would only be able to use the free text form. So what are the advantages of the pre-populated form? As the name suggests, this form pre-populates with the exact information from the USPTO database, so transcription mistakes are unlikely. And as mentioned earlier, if no changes are made, the international application is automatically certified and transmitted to the International Bureau. Next slide. So I think I covered this slide, so we'll just move on to the next slide. So what are the disadvantages of using the pre-populated form? Most notably, pre-population of data containing errors or incorrect information. For example, if there is a typo or error in the U.S. application or registration, this error will also appear in the international application and ultimately the international registration. Errors might include typos, incorrect punctuations in the owner name or listing of the goods and services, or an incorrect indication of the mark type. Because international applications cannot be corrected or amended, this may result in a denial of certification or ultimately affect protection in the designated contracting parties. So if there are any errors or incorrect information in the U.S. application or registration, you should correct that prior to filing the international application if time permits, or consider using the free text form. Next slide. So the Madrid Processing Unit, or MPU, processes all the international applications for the USPTO as the Office of Origin. MPU reviews each international application and compares information with each basic application or registration to determine if all the filing requirements are met, and will either certify and forward the international application to the International Bureau or deny certification and send the applicant a letter setting forth the reasons for the denial. If denied certification, the international filing fees will be refunded, but the USPTO certification fees will not. Next slide. So the next few slides highlight some of the key elements MPU reviews for certification. And if there are discrepancies, a denial of certification will likely issue. The first is ownership. Here, we're looking at the owner name, entity designation, and citizenship. They must be identical. For example, if the owner name in the basic application includes Inc., the owner name in the international application must also include Inc. Reproduction and description of the mark. This includes color claims as well. They must be the same. For example, if the basic application or registration includes a mark description, then the same mark description must be included in the international application. If the mark in the basic application is in color, then the mark in the international application must also be in color. Standard character claims, These claims must be present in all the basic applications or registrations that form the basis of the international application. Next slide. Also, the international application must include an indication for certain types of marks. Specifically, if the basic application or registration is a three-dimensional mark, sound mark, collective, or certification mark. So please be sure of what you are filing and what you are asserting in your international application before filing. Next slide. The goods and services are also reviewed for certification. Essentially, the listing of the goods and services in the international application must be the same as or less than the goods and services in the basic application or registration. But be aware that the goods and services listed in the international application must be within scope of the basic applications and the registrations when MPU actually reviews the international application for certification. So if the identification of goods and services in the basic application was amended before MPU reviewed the international application, depending on the nature of the amendments, a denial of certification may issue if the goods are no longer within scope in the international application. As for limitations, this refers to limiting or narrowing the listing of goods and services specific to each designated contracting party. Note, however, that the USPTO does not review limitations for certification purposes. Next slide. And though the identification of goods and services is reviewed for certification, MPU does not certify classification of those goods and services listing in the international application. Classification is solely determined by the International Bureau pursuant to the NEAS classification in effect as of the filing date of the international application. Currently, it is the NEAS classification 11th edition version 2020. So while the listing of goods and services in the international application does not have to be classified in the same class as in the basic application or registration, be aware that improperly classified goods or services will likely result in the issuance of a notice of irregularity from the IB. Next slide. The international registration date. The international registration date is the date the international application is received by the USPTO, provided that the International Bureau receives that international application from the USPTO within 2 months of receipt by the USPTO. This is true even with applications with a claim of priority. So for international applications that include that claim of priority, so long as the international application is filed with the USPTO on or before the last day of the 6-month priority period, the USPTO has 2 months to get that application to the IB. If, however, the international application is received by the IB after that 2-month window, the international registration date will be the date of receipt by the IB, basically the date when the IB receives the international application from us. Next page. How to avoid a denial of certification. Next page. So these are some general practice tips to consider before filing an international application. Review and correct any errors or inconsistencies before filing the international application. And when reviewing information in the USPTO database, please use TSDR, or the Trademark Status and Document Retrieval System, rather than TESS, the Trademark Electronic Search System. Because of the way TESS displays certain fields, we suggest that you rely on the information that is displayed in TSDR. Next page. So how to correct errors or inconsistencies before filing. So if you note that there is an error or inconsistency in the basic application, you can contact the assigned examining attorney to request an amendment or the correction. If an examining attorney has not yet been assigned, you can file a voluntary amendment. If the error or inconsistency is in the basic registration, you can file a Section 7 amendment with the post-registration unit, or if appropriate, file an assignment with the assignment recordation branch. However, again, be mindful of timing when filing the assignment. USPTO records may not have yet updated to reflect the assignment, so depending on when the international application was filed, when MPU actually reviews the international application, the owner name may be inconsistent, and that would warrant a denial of certification. So it would be optimal to wait until the assignment has been recorded and the USPTO database has updated to the correct owner name before filing the international application. Next page. Since we've covered most of this information, we will just move on to the next slide. Denial of certification. As discussed earlier, MPU will review the international application to determine if it meets certain filing requirements. If MPU denies certification, a letter is issued explaining the reasons for the denial. This is a final decision and does not permit the applicant to file a response or otherwise amend the international application. However, the letter will outline the applicant's options, which are to file a new international application, basically to start over, or to file a petition to the director to review denial of certification. Next page. So the petition to review denial of certification is an online form that is available through the USPTO website. This petition is a request to the director of the USPTO to review MPU's decision or exercise authority to permit applicant to correct minor mistakes in the international application. Sometimes the issues can be a little convoluted, so if there are any questions, we do encourage applicants to contact us before filing the international application or the petition. Next page. Some things to consider when filing a petition. Timeliness. Please be aware of that 2-month window. The international application must be certified by the USPTO and received by the International Bureau within 2 months of receipt at the USPTO in order to preserve that filing date as the international registration date. And if the submitted international application contains errors, together with the petition, a substitute paper international application, which is the MM2 that Debbie talked about earlier, that's also got to be submitted. This form can be downloaded from WIPO's website. So while the originally filed international application cannot be corrected or amended, a substitute application, the MM2, once it is reviewed and determined to be acceptable, can be certified and sent to the IB. And again, because of this 2-month window, these petitions are expedited for review by a petition staff attorney. So be sure you're filing the correct petition form and to file as soon as practicable. Next slide. This slide covers a couple of other considerations that we're not going to spend too much time on. Just wanted to mention that international applications can be based on U.S. applications pending or registrations issued by the USPTO on the supplemental register. And the next slide will be back to Debbie.
Thanks, Kelly. So Kelly touched on subsequent designations at the very beginning, but just to kind of recap, because we're throwing a lot of new terminology at you. The subsequent designation is a request you file to seek protection in additional countries that you did not include in the international application when you filed it, or to seek protection for additional goods and services that weren't covered in a previous designation to a country. So the core thing to keep in mind throughout this process is that the international registration sits in the middle of all of this. So you can't add goods or services that are not covered by the international registration. So you're always going to be limited to what's in the international registration. But that's the function of the subsequent designation. It can only be filed once the international registration issues, so you're going to need that number when you file it. You can file it with us using a TEASi form, or you can file it directly with the IB. They have a fully electronic MM4 form for that purpose. If you file directly with the IB, the form will be processed more quickly because you're eliminating the USPTO as the middleman, so that's an advantage. If you file with us, we charge a $100 non-refundable transmittal fee, but the advantage is that you pay in US dollars instead of Swiss francs. You should know that we don't review subsequent designations for any requirements. We are simply forwarding on to the International Bureau whatever you file with us. So that is our function. So if you file directly with the IB, you can skip the $100 fee, but then you'll be paying in Swiss francs. That's kind of the nuts and bolts of that. You want to be mindful of the renewal date of the international registration. Again, the international registration sits in the middle of this entire process. So when the international registration expires, all of the designations expire. So everything is linked. All of the country designations, all of your baby trademark applications and registrations that emanated from that international registration will expire when the IR expires. So just keep in mind your renewal date. When you file a subsequent designation, your default filing date is the date received at the USPTO if the IB receives it within 2 months of that date. Otherwise, it's the date received at the IB. Obviously, if you file at the IB, it's going to be the date it was received at the IB. However, on the form, you can indicate, and this is also the USPTO form as well as the IB form, you can indicate that you want the subsequent designation to take effect after the renewal of the international registration or after some change to the international registration has taken effect. So you do have those options when you file the form. They're checkboxes, basically. And then also we have a point on the slide that there are some parties that you can designate only if your international registration date is after the date they joined the Madrid Protocol. That is an option when countries join the protocol. Currently, there are only the 5 countries listed that have opted in this way, but if you file using one of our forms and you designate a country, or you try to designate one of these countries and your international registration date precedes their accession date, that option will be grayed out. The form won't let you do it. And now I'm going to let Kelly talk about notices of irregularity.
Thank you. So now we're on notices of irregularity. So what is that? A notice of irregularity is a notice from the International Bureau concerning deficiencies in the international application that will require correction from the applicant or the USPTO. So when the International Bureau receives the certified international application from the USPTO, it will be reviewed for formalities, not for substantive issues, and as a result of that review, may issue a notice of irregularity for deficiencies, including the identification or classification of goods and services or fees. Next slide. So how to respond to a notice of irregularity. Depending on the type of deficiency or irregularity, it may be remedied by the USPTO. For example, a drawing was omitted from the international application, or by the applicant directly with the IB for perhaps missing fees, or by the applicant through the USPTO, where the USPTO will review the response and forward to the IB. And this is when the irregularity concerns the identification of goods and services. If you wanted additional information on the identification or classification of goods and services, you can see Rules 12 and 13 of the regulations under the protocol. Next slide. So the deadline for responding to a notice of irregularity is generally 3 months, and the due date will be clearly indicated on the notice that you receive. if the response has to be filed through the USPTO, we do encourage you to file that response early so that MPU has sufficient time to review and forward to the International Bureau. If your response is received by the USPTO after the response deadline, MPU will not process it and it will not be forwarded to the IB. Next slide. So this is the response to notice of irregularity form that's available online on the USPTO website. And that's obviously the form that you would use to submit that response if it's got to be through the USPTO. Next slide. Once the response to the notice of irregularity form has been submitted, it will route to MPU. An MPU specialist will review the amended goods and services in the response. If the amended goods and services in the response exceed the scope of the goods and services listed in the basic application or registration, MPU will not forward that response to the IB and will notify the applicant accordingly. If the International Bureau's deadline has not yet expired, then the applicant can submit a new response. And if that new response is acceptable, MPU will forward that to the IB. So filing response early provides this additional time to allow for a potential second response to be filed for submission to the IB. Next slide. So what happens if a response to the notice of irregularity is not timely submitted to the International Bureau? If an irregularity concerning unacceptable wording or terms in the listing of the goods and services is not remedied, the IB may include the unacceptable wording or terms in the international registration with bracketed indication that the IB considers such wording terms to be too vague for purposes of classification. And that's if classification was provided in the application. If classification was not provided, then the unacceptable wording would be deleted and the USPTO and the applicant would be notified of such. But again, if the irregularity concerned fees and no response was timely filed, the IB will likely abandon the international application. Next slide, and back to you, Debbie.
Thank you. Okay, so this is the last section of the presentation, and I'm going to talk to you about what happens after the international registration issues. So we're going to spend a little bit of time talking about dependency and ceasings of effect, and then some information on maintaining your international registration and making changes to it. Okay, dependency. This is important. It's one of the core principles of the Madrid system. As we've been discussing all along, your application for the international registration must be based on one or more U.S. trademark applications or registrations. Those are your basics, your basic application, your basic registration. The rest of the story is that the international registration continues to be tied to your basic application or registration for a period of 5 years from the date the international registration issues. So 5 years from the registration date of the IR. This means that if the basic application or registration dies within that 5-year dependency period, the international registration dies. Or if the listing of goods and services in the basic application or registration is restricted within that 5-year dependency period, that restriction is going to be translated into the listing of goods and services in the international registration. So what happens in the basic is going to get translated into your international registration during that 5-year dependency period. Just keep that in mind. We notify the International Bureau of these changes via a notice called a ceasing of effect. And then the other important concept, and I talked about this a little bit when I was talking about subsequent designations, is that dependency works in concert with this feature of the system that all the designations are tied to the international registration. So what happens to the international registration is going to happen to all of the designations, all of the baby trademark applications and registrations that emanated from the international registration. So if the basic application or registration is abandoned or if it's canceled, your international registration is going to be canceled, and then all of your designations are going to be canceled as well. This is how dependency works. Same thing for restrictions of goods and services. If your listing of goods and services in your basic application or registration is restricted, that is going to be reflected in the international registration. It will be narrowed accordingly. And then that same restriction of goods and services is going to be translated into all of the designations. So all of your designations will be restricted accordingly. And I think that is what I wanted to talk about. Oh, no, I did want to say one more point. When the 5-year dependency period ends, then the international registration is free of the basic. So you don't have to worry about it after that 5-year period. It's automatic. I'm going to skip this. I've talked about this. I just did it all on the first slide. So this slide, we're going to talk a little bit about, just to clarify, what are the types of things that get notified to the IB in a ceasing of effect. The only thing that we are concerned about in a ceasing of effect are changes to the scope of protection in the basic application or registration. So what that boils down to is, was there a change to the listing of goods and services, or did the basic application or registration die? Those are the things that we notify. So what are the things that don't get notified include things like, oh, you had an amendment to the drawing during prosecution, or the mark description changed, or a translation statement change, a change in owner, owner address. None of these things are notified to the International Bureau. So keep that in mind. If you file your international application while the basic is still pending or early on in the situation, you may have some negative impacts to your international registration that you may not have intended. So for that reason, we encourage applicants to wait until at least you get your first office action on the basic application. And in case you're worried about timing, your priority claim is valid so long as your application is filed within 6 months of filing the U.S. basic. So you've got 6 months to play with. And right now, office pendency is at 2.6 months. So you should receive your first office action within 3 months of filing your basic. And then you'll have a sense of, is there, is there a substantive refusal? Am I going to have to reclassify goods and services or something like that? You should have a sense of that within 3 months, and then you still have time to file your international application. Here's some examples, just because we're going to drill this point home with you. You might run into a problem if the mark is amended during prosecution. And again, I'm talking about in the basic application. So an example that happens, from time to time is that a hyphen in the mark will be deleted. If you've already filed your international application with the hyphen in the mark, there's no way to go back and amend the mark in the international registration. You're stuck with the mark with the hyphen. And then also what will happen from time to time is, and this is less common, but it could happen, is that someone filed with a standard character mark and then they decided to amend the drawing to wording in a stylized font, which is permissible as long as it's not material. And you cannot make a corresponding change in your international registration. Your drawing is set forth when you file your international application. Another problem we see from time to time, this creates issues, is changes in the classification of goods and services. So what will happen from time to time is people will file for a listing of goods and services. The example we have here is this is a broad ID for goods in class 25 is what they filed in the basic for headgear. Well, headgear will allow you to amend to any clothing in class 25, any headgear in class 25, as well as any headgear, protective headgear in class 9. So let's say the ID in the basic is amended to motorcycle helmets in Class 9. If you had filed your international application immediately, it would go to the International Bureau with headgear in Class 25. Well, when your basic application registers with motorcycle helmets in Class 9, we have to send a ceasing notice to the international registration to let them know that your ID is now motorcycle helmets, but we can't change the class. The classification is permanently set to Class 25. So we will be sending a ceasing notice that what remains protected is motorcycle helmets in Class 25. There's a legal question as to how the jurisdictions where you filed your designations are going to handle that. Will they see that as you have nothing left protected in the mark? That's going to depend on national law as to how they handle that. So just be aware that class changes can potentially be problematic for you. Okay, and now that I've scared you, I'm going to talk about maintaining an international registration. Okay, so the international registration is valid for 10 years, and that renewal period commences with the date of the registration date of your international registration. You have to file your renewal directly with the International Bureau. This is going to be the theme for the rest of this presentation, that you have to file things directly with the IB. They have a fully electronic renewal form you can use, or a downloadable PDF MM11 form, both of which are found on WIPO's website. We don't process or forward these. You have to go right to them. So if you contact us, we're going to send you right over to WIPO. And as I've said before, if it's not renewed, if your international registration is not renewed, it will be canceled. And then all of the designations, all of your trademark applications and registrations that emanated from that international registration will also be canceled. So renewals are maintained centrally at the International Bureau. For changes to an international registration, once again, we're going out to the IB in order to make these. So I have some listing of forms here that tell you which forms you can do what with, but just some high points here. If you want to file an assignment, that's on the MM5 form. The IB also has a separate form if you have a non-transfer change in owner name or address or entity type. That's the MM9 form. There's a little error here on the slide. If you have a change in the representative, so this is the representative that's appointed for the applicant before the International Bureau, that is filed on the MM12 form. And if you want to have a name change of that party or an address change of that party, that's on the MM10 form. And then the last three options, well, I'll just talk about them individually. We've got a little time. The limitation of goods and services, that is a restriction to an identification of goods and services that pertains only to one or more of the designations. So it does not pertain to the international registration. That's on the MM6. A renunciation, that is like a surrender, and it applies also to a designation or one or more designations, and that's the MM7 form. If you want to cancel the international registration in whole or in part, that's the MM8. And a cancellation in part is basically deleting some goods or services out of the international registration. So if you're doing that or you want to cancel it entirely, that's the MM8 form. And the link is the direct link to where you find the forms on the WIPO website. I'm not going to go through this entirely. I'm going to hit the high point. The main point I want you to take away from this is that if you need to file an assignment, keep in mind that the IB doesn't require evidence of the change in ownership. So you don't send supporting documents to the IB. They don't want it. They don't need it. This is a very European bureaucracy. They want the form. Just fill out the form. And then this is my exception to file everything at the IB. So the MM5 is your assignment, your change of holder form, and generally speaking, it's going to be filed at the IB. However, the form requires the signatures of the assignor and the assignee. So what if the assignee can't get the signature of the assignor? And this is when we have our little special quirky situation. Under these circumstances, the Madrid system provides for filing the MM5 with the national office rather than the IB when the assignee meets the Madrid entitlement criteria, meaning you're a citizen, you're domiciled in, or have a real and effective industrial or commercial presence in the jurisdiction, and when the assignment pertains to an IR that's based on basic application or registration from that jurisdiction or applies to a designation to that jurisdiction. So in the context of what we're talking about, the assignee has to be a citizen, domiciled in, or have a real and effective industrial or commercial presence in the United States, and the assignment pertains to an international registration based on a U.S. application or registration, or it pertains to a designation to the United States, which is an incoming Madrid-based application or registration. We don't have a special electronic form to file this. We only get a handful of these a year, so you have to download and complete the official copy of the MM5 form from the WIPO website and attach it to a petition to the director for an international application or registration, and that's how you do this. We do charge a $100 non-refundable transmittal fee, and keep in mind there's no back and forth, so either it meets the requirements and we send it, or it doesn't and we don't. All of the very specific requirements for this are set out in Trademark Rule 7.23, so I encourage you to take a look at that if you find yourself in this situation. Okay, and finally, we have some important trademark contact information for you. We have the contact information for the assignments recordation branch, the Madrid processing unit, the petitions office, and if you have problems with an electronic form, please email the TEAS email box is teas@uspto.gov, and that's manned between 8 a.m. and 8 p.m. And then if you just have general, how do I file this questions, those can be directed to the Trademark Assistance Center. And the contact information is there for that. So we are going to transition to the question and answer portion of the presentation. I just want to remind you to put your questions in the chat window. I see a lot of you have already figured that out. Or heard the announcement at the very beginning, so thank you for that. And you want to make sure that in the little to field, the little drop down, you select all panelists, and that way we can view it. And we're going to take a minute to just pull those questions for you. Okay, actually, while we're pulling questions, let me just, because I did see a couple of pop-up questions come in during the presentation. So somebody had asked about whether they will get copies of the slides, and we just want to remind you that a link to the slides will be shared with all attendees that registered. So everybody will get a copy of the slides or a link to the slides, so those will be made available.
And also a recording of the presentation will be posted on the USPTO website. So I did see one question regarding the payment and refund of fees. So if I'm understanding the question correctly, if an international application is filed and it is denied certification, all the relevant international filing fees will be automatically refunded back to you. The only fees that will not be refunded is the certification fees. And if at that point you decide to just refile a whole new international application, you would obviously have to repay those international application fees, which were refunded to you before. And unfortunately, you have to pay the additional certification fee because it's a new international application.
And we also had a question about transformation. We have a couple of questions about transformation. I'm going to read them. If the U.S. basic application or registration is canceled or abandoned, isn't it possible to nationalize the IR designations and keep the registration in the designated countries? Yes, thank you for asking that question. So we were talking about the worst possible case scenario where your basic dies and your international registration is canceled. So you have a provision in the treaty that when the international registration is canceled because of a ceasing of effect, so the death of the basic application or registration, you have the ability to file what is called a request for transformation. It is within a 3-month deadline, so you need to be vigilant of this, be vigilant of the death of the IR so that you can stay on top of your deadlines. But essentially what happens is you file a request for transformation in the jurisdiction of the designation. So you filed from the US, you designated France, and your basic died, and then you have to file your request for transformation in France. And you're requesting to have your registered or pending extension of protection transformed into a national application or registration. So that's how that works.
So there's a question with the subsequent designation. The subsequent designation would only be made after the International Bureau issues the international registration. So if it hasn't issued yet, you would have to wait for the application to issue as a registration, and then you can file subsequent designations.
We have a question about local counsel. I'm going to read that. I was under the impression that after filing an international application, you need a foreign correspondent if you received an official action from a particular country. Okay, this is very jurisdiction dependent. So it is definitely true that it is more common that most foreign jurisdictions do require local counsel in order to respond to an office action from their IP office. But it is jurisdiction dependent. So it's not an across the board rule. It's not a feature of the treaty. It's controlled by national law. And then I'm going to answer a related question, which is, can a U.S. attorney file directly forms with the IB, or do you need international counsel? A U.S. attorney, actually, the International Bureau doesn't require that the representatives before the IB be attorneys at all. They just are representing the applicant. So, and I think what they're relying on are local rules for representation, perhaps. I'm not really sure. But yes, a U.S. attorney can file forms directly with the IB, absolutely.
So we have a question to explain the difference between the 2-month priority and 6-month priority. So the 2-month and the 6-month priority window that we were talking about during today's presentation really pertains to, one, the international registration date. We have, when you file your international application with the USPTO, we have 2 months to get that international application to the IB in order for you to preserve that filing date. The 6-month claim of priority has to do with claiming priority. So if you filed an application in the U.S. and it's pending, you have 6 months to claim priority on that filing date when you file the international application, and that will carry through to the international application. So those 2 dates are not really a priority. One really has to do with the window of us filing the international application or getting that international application to the IB, and one just has to do with the claim of priority. So I hope I answered that question.
We got a question asking about, I'm just going to read the question. I noticed that in some instances, we receive notifications from designated countries with a different registration date. However, it seems that we should not necessarily pay attention to these registration dates, rather only the IR registration date in terms of docketing for a renewal. Is this true? Okay, so in terms of filing renewals, yes, the renewal deadline for the trademark is going to be tied to the international registration date. However, different jurisdictions have additional maintenance filing requirements. For example, the United States, this isn't applicable in this context, but just as an example, we require showings of use, periodic showings of use in order to maintain your registration. So even if someone were filing from Madrid to us, they still have to meet those requirements. So you're definitely going to want to check local, the national law where those designations are registered to see if you have any additional maintenance requirements beyond filing a renewal.
So there is a question about the difference between a home application and a claim of priority on the international application forms. It depends. So if your international application is based on, let's say, one application and you're asserting a claim of priority based on that one application and you're within the 6-month priority period, then yes, in your international application, the basic application and the application number of which you're claiming priority would be the same serial number. If you're basing your international application on multiple applications or on a combination of an application or registration, obviously that would differ. The listing of the various basic applications or basic registrations would be a listing of all the applications and registrations that you are utilizing, and the claim of priority would be only those where you're within that 6-month window of claiming priority.
We have a question where someone is asking if we can make changes to an international registration with the IB prior to the termination of the 5-year dependency period. And the answer is yes. Now, the types of changes you'll be filing would be, changes in the scope of the ID, changes in ownership, those types of things. So as we said, you can't change the drawing. You can't do those types of changes at all, and dependency has nothing to do with it. But you can file, let's say you want to restrict the goods and services in the international registration. That's the cancellation form. You'll just cancel it as to only particular goods and services. And again, if you're filing a change of ownership or if you want to change the owner address or something like that, definitely.
Can a mark registered on the supplemental register be a basic application for an international application? The answer is yes. Pending applications or registrations on the supplemental register can be a basis for an international application.
And a question I absolutely love. They filed on May 15th and received confirmation that we received the filing, and that confirmation receipt contains a reference number. Where do I check on the status of the filing? TSDR, this is so exciting. So the reference number that is assigned to the international application starts with a letter. And if you go to the trademark document status, TSDR system. I can pull it up here in a second and show you. You can use your reference number there where you would normally put in an application serial number or a registration number, and it will pull up the file for you, and then you can view all the documents in that file. And I will just go a little crazy here and show you what I'm talking about. Oops. Here's my little link. TSDR at USPTO.gov. It takes a reference number, and I don't actually happen to have one handy off the top of my head, but, or actually, this you should probably never do. But it is all public record. So status gives you the status. And if you click on documents, you can see everything that's happened in the application. I'm going to switch back over so you can see the contact information again.
So we have a question about how do you know which designated countries are still active in your international registration? So the simplest answer would really be to go to WIPO's website. It's a fairly straightforward website that's pretty easily searchable. You just have to type in your international registration number in the little search function, and all the various documents, the basic goods and services listing, the countries that were originally designated, and all of the subsequent communications from the designated countries. It should all appear on that website, and that would probably be the best way that you could figure out what's going on with your international registration.
There's a question. Someone asked if it's possible to file forms like the MM6 with the USPTO, or do the forms have to be filed directly with WIPO? So the MM6 is a limitation form. That form needs to be filed directly with WIPO. When in doubt, the form has to be filed with WIPO. The exceptions are the international application form, obviously, that comes through us. You can file the subsequent designation with us or with the IB. Once the international registration has issued, you have to have the international registration number. I'm sort of folding in another question. You have to have an international registration number in order to file the subsequent designation. However, limitations, I'm not sure if you were asking specifically about that form, the MM6, or if you were asking about limitations as a filing. So when you file your international application, or if you're filing a subsequent designation, you can include limitations to the goods and services for specific countries that you're designating. So you can do that in those forms. But if you're filing it separately from the international application or the subsequent designation, then you're using the MM6 form, and that does have to be filed directly with the IB.
So we have a question about the best way to update the owner information with the USPTO before filing the international registration. So if you've already filed the assignment, it does, depending on which day you filed it, the assignments are auto updated, I believe, on Wednesday nights. So if you kind of fall in that awkward period where you need to file the international application prior to the update, you can just go ahead and file the using the free text form, enter the correct information. So let's say the owner information has not changed in the USPTO records. You want to clearly identify the correct owner name in your international application form, and will probably get denied certification. At that point, we can pull the international application, and once the record has updated, or if it hasn't, we can look into that to ensure that it has updated, and that will probably be, depending again on your timing issue, if there's a claim of priority, that's probably the most expedient way to file the international application.
We're reading questions. We're trying to pull everything. We're getting them in batches. So my apologies for some of the delays in the timing it's taking us to get to the questions. Somebody had a follow-up question on transformation because I did not cover this. And the question is, if some classes, but not all, are deleted from the basic US application, is transformation available for the canceled classes? Yeah, it's called a partial transformation. You can absolutely transform goods and services that were deleted from the designation because those goods or services were deleted from the basic application or registration. So you can file a partial transformation. It's not class-based. It's actually based on the goods and services.
So there's a question about whether the international registration is only effective if the designated countries approves it for registration in the country. So the international registration is issued by the International Bureau. And once that IR issues, it is notified through the request for extension of protection to whichever countries you want to designate. So if there are some countries that you designate that, for whatever reason, issues a refusal and you are not able to actually get protection in those countries, it doesn't really affect the international registration at the IB level, because you can always take that international registration from the IB and subsequently designate other countries. Or perhaps in 10 years, that country that you really want to get protection in, perhaps in 10 years, you will refile via subsequent designation and get protection then. So it's not that it's not effective. The international registration sort of stands on its own at the International Bureau, and how and the scope of your use of that international registration to designate the contracting parties, that's really going to determine the scope of your protection worldwide. Debbie, I'm going to jump ahead of you if you don't mind.
No, go ahead.
So this is a great question. So the question is the 2-month window for the PTO to get the application to the IB, how often does that window not get met? And what can the applicant do to make sure that this 2-month window gets met? So the short answer is, if you receive a denial of certification and you intend to file a petition, file that petition as soon as possible. If you file that petition quickly, there's no reason why we wouldn't be able to work through the issues. Having said that, if there's some deep substantive issue for the denial of cert, again, we would have to look at the specifics of it. But in order to ensure that that 2-month window gets met, you would need to file that petition as quickly as possible. If you wait till, let's say, the last day of that 2-month window, I mean, it's sort of difficult to review the petition, and if there's a substitute MM2 involved, to review the substitute MM2 to ensure that all the information is correct, and then to grant the petition, and then to transmit that to the IB, because it's got to be received by the IB. It's not the date that the USPTO sends the international application, it's when the IB receives it. So if I can just say this one more time, if you can file that petition as quickly as possible, that definitely goes a long way.
I'm going to read a question that I can't answer because I think it's actually worth reading the question. If we have to comply with all local jurisdictions and presumably retain local counsel, what is the relative frequency of local issues coming up? That is a question that we don't have the data on. We don't have any of the statistics on how frequently other offices are issuing refusals and what are the common bases. However, the International Bureau does track some of that information. So it would be worthwhile going out to the WIPO website and taking a look at their statistics. If you start from that Madrid page that I showed you, they do have links to their filing statistics. And then because there are a number of questions that we've received that actually do pertain to local, to national law and local rules, I wanted to let you know that the International Bureau also maintains a database that contains legal information or information about the laws and practice of all the Madrid member states. So that database is also linked from that Madrid webpage. And the information is not updated by the International Bureau. It is updated and it's maintained by the different national offices. So the different national IP offices are responsible for the content in that database, which is good in the sense that you're getting it from an authority, but sometimes it can be challenging depending on, how frequently they are able to update that information and keep it current. So the relevance for you may depend from country to country, but it is definitely an excellent resource to get a feel for how their practice might be different. For example, are you filing into a jurisdiction that does not do any searching of the mark before the registration issues? Super important to know what your registration means. So that's an example.
We have a question about whether Madrid filings through the USPTO is subject to the U.S. Counsel rule. Debbie, do you want to take that one?
Yeah, it's a squeegee answer. Technically, yes, but our system, the international application form and the subsequent designation forms, we were not able to update the back end of the system to accommodate the U.S. Counsel information to make it mandatory. So so the answer is yes. It's encompassed by the rule change, but the forms are not enforcing it, and we're not going to deny certification for that reason. Okay, I have another question about ceasing of effects. Where the international registration is already past 5 years old when a subsequent designation is filed, will there be a ceasing of effect issue in play? I sort of reworded your question, but sorry. But that's the meat of the question. And the answer is the dependency period. You've got it. Intuitively, I think you understand it. The dependency period is linked to the registration date of the international registration. So if that registration is already past the dependency period, if it's older than 5 years, then all of the designations are free. The dependency period and the ceasing of effects are no longer an issue across the board. So it doesn't matter that you're filing a new subsequent designation. That's fine. Someone asked if goods can be added to the international registration, and that answer is no. The scope of the international registration cannot be changed. I think where the confusion came is when I was talking about subsequent designations, and I said one of the reasons you may want to file a subsequent designation is if you've already filed a designation in a country, let's say France, you've already designated France, and you want to expand the listing of goods and services based on the international registration that are in France. So when you filed initially, you only filed for some of the goods and services in France, so you filed a limitation. And now you're making money hand over fist, and you want to expand the scope of what you're selling in France. You can file a subsequent designation to indicate that you want to seek protection for additional goods and services so long as they are already included in the international registration. So the scope of the international registration, the outer scope of the international registration is set when you file your international application. At that point, from that point forward, all you can do is make it more narrow. Okay, so we haven't even put a dent in your questions, but it's 4:30. So I wanted to let you know, first of all, that any questions that you've asked that we were not able to get to, please email them to the TM Policy mailbox. That email address is tmpolicy, TMPOLICY, at USPTO.gov. And we will respond to your email from that mailbox. Also, we wanted to ask for your feedback on the webinar. We are always looking to improve what we do, and we would love to hear from you. So for that, please email any feedback you have to TM_webinar, WEBINAR, at USPTO.gov. Again, we really appreciate your comments and your suggestions. And I don't know, Kelly, if there are any other announcements I may have forgotten. I'm going to rely on you to jump in and save the day.
We keep getting questions about whether the presentation, the slides will be available. And again, both the recording of the presentation and the slides will be available on the USPTO website.
With that, thank you so much for attending. We really appreciate your participation, and have a great afternoon.